Ms. Harris, the 523A2A does not focus on the debtor, at least textually. It focuses on the debt. And it is in the passive voice, but it's talking about money or debt that's obtained by fraud. How do you convert that into a statute that is focusing on the debtor?
A few textual indications. First of all, the individual debtor runs throughout 523. It is the only identified actor who is the subject of the whole series of exceptions, and the individual debtor is the relevant actor, only relevant actor, in a lot of the other provisions. And second, we know that fraud, the term actual fraud, it's not just Congress using the passive voice. Congress is requiring fraudulent intent. And this court has recognized in cases like Dean and Wilson, when Congress is using the passive voice without intent requirements, that's when you're more likely to think Congress is indifferent to who's doing something. But when Congress requires culpability, that is very good evidence, and Congress actually cares quite a bit about who is performing the misconduct. And Bullock confirms that, because in that case, the court was confronting whether defalcation requires intent, and the court said that the A4 exception for defalcation, along with the A2A exception for fraud, the A6 exception for willful and malicious injury to property. I could go on. There's a couple of other tort-related things.
I understand that, but doesn't it work against you that some of these provisions that you're referring to actually speak in terms of the debtor and then refer specifically to the debtor? And if it does refer to the debtor in those provisions, doesn't that argue against including or treating this provision the exact same way that does not refer to the debtor?
Not given the nature of the bankruptcy code. And if you look at the way that Congress is using the word the debtor or not using the debtor, it's very similar to what happened in Hartford Underwriters with respect to using the word trustee, only trustee, or not trustee at all. The individual debtor is the star throughout. And just to give a couple of examples of exactly how arbitrary Congress was in using the debtor or not the debtor, take the contrast between 507A10 and 523A9. Those are two provisions that deal with the exact same type of debt. The debt is for someone who's engaged in drunk driving, kills someone. The debtor is operating the motor vehicle. The first one does not mention the debtor. The second one mentions the debtor. And to the idea that Congress attached talismanic significance to mentioning the debtor just doesn't seem to withstand scrutiny. Now, another example is just the history of how the bankruptcy code has been amended. So if you look at A4, for 70 years, it referred to his defalcation, meaning unambiguously the debtor's. But then in 1978, his disappeared. So if you think that there is a huge significance for whether the debtor is referred to or not, that would have been a sea change, but no one noticed it. Or if you take A6, converse problem. You have a provision that did not mention the debtor until 1978, added the words the debtor, and again, no one seemed to notice that there was apparently a massive change in meaning.